Hello and welcome. I'm Una Fitzgerald, President of the International Law Association of Canada, ILA Canada, and Senior Fellow with the Human Rights Research and Education Center of the University of Ottawa. I have the pleasure of moderating this distinguished noon-hour panel on international environmental law developments. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of Indigenous peoples. We are meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. We are grateful to live on, learn from, and enjoy this land, and commit ourselves to decolonization in our personal lives, our businesses, organizations, schools, and in our communities. The commitments we make in this land acknowledgement must be actively pursued and come with the belief that decolonization begins with reconciliation with all Indigenous peoples, inclusive of First Nations, Inuit, and Métis peoples. If reconciliation is to be successful, we must continue to deepen the ways in which we listen to, learn from, and support Indigenous peoples in their resilience, resistance, and self-determination. So the International Law Association of Canada is the Canadian branch of the International Law Association, which is based in London, England, and was founded in Brussels, Belgium in 1873. With over 4,500 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. Our membership is global and diverse, and our members provide a full range of international law services to the state and non-state actors that shape our current socio-economic, environmental, and political context. Comprised of legal scholars, legal practitioners, students, and policymakers, the ILA Global Network and its regional and national branches contribute to the work of ILA research committees on important topics of international law. They also hold biannual conferences. The last one was in Athens. The next one is in Vienna in 2026. ILA organizes panels and workshops on a wide range of international law issues, such as this one today. Well, as you have seen, this has been a very eventful year for the planet in terms of international environmental law. We've had 3 COPs, quite unimaginable. We've had the Biodiversity, Desertification, and Climate Change COPs. There have been a lot of discussions about climate finance. There's been efforts to get that plastic pollution treaty in place. And there's been many instances for Indigenous people involvement in these difficult processes. And we're going to hear today about that and what some of the challenges are. So as I mentioned, we've got some very distinguished speakers. And the format will be that each one will answer 3 questions, and we'll go through them one at a time. I will begin by introducing our first speaker, and that is Payam Akhavan. Payam is an Iranian-born Canadian lawyer. He is nominated as a member of the Permanent Court of Arbitration at The Hague by Bangladesh. He is a senior fellow at Massey Hall at the University of Toronto and is a visiting adjunct at his Faculty of Law. He was previously legal advisor to the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia at The Hague and special advisor to the International Criminal Tribunal for Rwanda. He has served as legal counsel in cases before the International Court of Justice, the International Criminal Court, the European Court of Human Rights, and the Supreme Courts of Canada and the United States. Payam will discuss international environmental litigation developments such as ITLAS, the European Court of Human Rights, and of course the International Court of Justice hearings that are going on right now. So with those words of introduction, over to Payam to answer 3 basic questions. What's happened? What are the implications? And what can we expect? Hope next. Thank you, Payam.
Thank you very much. And it's an honor to be on this panel with distinguished colleagues. And I'm grateful to the International Law Association of Canada for addressing what has really been one of the most remarkable years in terms of litigation before international courts and tribunals on climate change. And we have literally gone from 0 to 100 miles an hour in 2024, beginning with the unanimous opinion of ITLOS, the International Tribunal for the Law of the Sea, in May of this year, on the impact of climate change on obligations of states to preserve and protect the marine environment. And now currently here in The Hague, the unprecedented hearings before the International Court of Justice on the wider obligation of states to address issues of climate change. And earlier this year, also the European Court of Human Rights delivered a judgment brought by a group of pensioners in Switzerland, also in respect of the impacts of climate change on the protection of human rights under the European Convention. And the Inter-American Court of Human Rights also this year held hearings on the so-called climate emergency on a request by Chile in Colombia. And it's anticipated that in the very near future, the opinion of the Inter-American Court will also be delivered. So it's a period of extraordinary development in jurisprudence. And what I wish to focus on is the role of small island states, the canary in the coal mine of climate catastrophe, in turning from what is essentially the failings of the COP process to international courts and tribunals. And this brings me to COP26 in Glasgow in 2021, when the Caribbean nation of Antigua and Barbuda and the Pacific nation of Tuvalu established the Commission of Small Island States on Climate Change and International Law. And since then, 7 other states from the Caribbean and Pacific have joined. There are now 9 members in this newly established international organization. And they, in December of 2022, requested the first ever advisory opinion, especially on the obligations of states under the 1982 UN Convention on the Law of the Sea to protect and preserve the marine environment. A couple of quick points which are important. First of all, why would these small island states lead the way? Well, in the case of the Caribbean small island states, given the unprecedented severity of extreme weather events which cause extensive devastation, the small island states are caught in a debt trap, a cycle of ever greater borrowing to rebuild what will eventually be destroyed again because of the unprecedented ferocity of extreme weather events, which are linked directly to climate change. In the case of the Pacific small island states, the situation is even more dire because Tuvalu, an atoll in the South Pacific, which on average is just 1.5 meters above sea level, will literally disappear because of rising sea levels. And the point of equity here is that these small island states in the Pacific, overwhelmingly indigenous peoples, have made negligible contributions to the problem of anthropogenic greenhouse gas emissions, but they are paying the heaviest price. And the COP process, which of course began with the entry into force of the UN Framework Convention on Climate Change 30 years ago in 1994, was intended to provide a framework for mitigation, for addressing global warming. But some 30 years later, based on the so-called nationally determined contributions of states under the Paris Agreement, instead of being on target to remain within 1.5 degrees Celsius by the year 2100, the current commitments are such that we will possibly reach 3 degrees Celsius, which will bring us to nothing short of a dystopian future. In fact, it's a remarkable coincidence that in the same year that there is this proliferation of international courts and tribunals addressing this issue, we have already surpassed the 1.5 degree Celsius threshold. And the science tells us that with every increment thereafter, there will be an exponential rise in the risk of catastrophic harm from climate change. So this is the reason why the small island states, in a sense, out of desperation, have turned to international courts and tribunals because of the understanding that much of what they have demanded in terms of mitigation of emissions, in terms of loss and damages for the injury that has been caused to them, is already part of binding international law. And one simply has to apply the basic principles of transboundary harm and possibly, in addition, principles of human rights to arrive at the conclusion that a state that allows activities on its territory to knowingly cause harm to another state is liable for breaches of its obligations and liable for reparations, including compensation. So the power of the case that the small island states are putting forward is in its simplicity. And what we have seen in these proceedings are the countries of the global north and the petrostates in particular using the Paris Agreement as a shield against wider obligations in international law, using a lex specialis argument, so to say, that this specialized regime expresses the intentions of the states such that it modifies or displaces general norms of international law. And of course, the Paris Agreement is essentially a set of procedural obligations whereby states must communicate unilateral nationally determined contributions, which should be progressively ambitious. But that says very little about what states actually need to do to prevent catastrophic harm. And that is why I began by saying that based on the nationally determined contributions, the world will reach 3 degrees Celsius by the year 2100, which explains why the small island states and other climate vulnerable states want to put some teeth, if you like, into the COP process to change the conversation, one negotiating endlessly while the planet burns to a discourse which is based on a binding international law. And I will end maybe with just one small observation as well. What has been remarkable as well is the voice of Indigenous peoples in these proceedings, in the rarefied halls of the Great Hall of Justice here in The Hague, where usually one has English barristers with wigs and French academics with red gowns and rabbit fur. Now we have, among many Indigenous representatives here, peoples from the Solomon Islands, Vanuatu, Tuvalu, who are, in a sense, by speaking about Indigenous legal traditions and the basic idea of harmony with nature, combining ancient wisdom with modern science to bring us to the conclusion that if we don't change course, then what the small island states are suffering now will become the fate of all humankind. So I will stop there, and I apologize if I'm not able to stay on for the duration of this panel to learn from my colleagues, but I'm very pleased once again that we have at least some lawyers in Canada that are paying attention to this very important issue.
Thank you very much, Payam. Would you have a minute in case any of the panelists have a question for you or a comment on what you have said?
Yes, of course, of course.
Okay. I'll just turn it to the other panelists if you'd like to ask a question of Payam or. Okay, I'm not seeing any questions from the panelists, but that's okay. We're all with you in spirit. Oh, sorry, I do have one person in the audience who has a question. Rayhan, can you put your question in the Q&A? Just one second. I'm not seeing the question in the Q&A. If you can put the question in the Q&A or the chat, Rayhan, we can answer it. On peut répondre à votre question. Wait another minute. Okay, well, I guess what I will just say, if we don't get that question, oh wait, has anything come in? No, not yet. I just say, Payam, we're definitely with you in spirit. We're going to be following the hearings with great attention. It's wonderful to hear that Indigenous peoples are participating and bringing those perspectives, because certainly from my point of view, it does seem that we do need a new approach to international law to to be able to address the challenges we're facing. So Ryan has put a question, and she's just asking for more explication of what you were saying. Is there more detail that you could provide quickly, Payam, before you have to go?
On the actual hearings,
I think so, yeah.
yes. Well, maybe just very quickly, the UN General Assembly in March of 2023 put a question to the International Court of Justice, the advisory opinion jurisdiction of which is limited to questions posed by UN organs and specialized agencies. And the question before the court is, what are the obligations of states in respect of climate change? And what are the consequences of the breach of those obligations? So it's a two-part question. And the first part really involves the basic principle of transboundary harm that I referred to earlier, but in addition, principles of human rights law, the right to a clean, healthy environment. And in addition, what some states have done, in particular the Indigenous Pacific Island nations, is to link climate change with the right of self-determination and even territorial integrity, given that they are literally losing their territory and their link which they have, the spiritual relation that they have with their ancestral lands, and how that's inextricably tied with their idea of exercising their right as a people. And the consequences relate to generally two basic principles of state responsibility. One is the obligation you must stop the unlawful act. And one of the questions is whether there is a legally binding obligation to transition away from fossil fuels, which is the most important way of preventing harm. And then the other issue is, well, if the harm has already been caused, then there is an obligation to pay compensation. And one interesting question is, beyond the abstract idea of compensation, how do you quantify the damage that should be paid, let's say, to a country that has disappeared, that has literally gone under the waves? So the issue is quite broad, overwhelming. I would just end by saying that I think this is a bit like the Nuremberg moment in international environmental law, in the sense that these advisory opinions, this flurry of activity this year, I think is just the beginning, certainly not the end of what will be some very significant developments, both in lawmaking and institution building in the coming years, as the reality of climate change hits us with ever greater violence, sadly, I must say.
Thanks so much for that explanation, Payam. And just to the audience, I would recommend that you find a way to watch the hearings, because there's so much to learn from it. And it's a wonderful way to see how international lawyers are trying to help address these really pressing and important questions. So all the best to you, Payam. And we'll now move to our next speaker, my dear colleague, Marie-Claire Cordonnier-Segar. Dr. Cordonnier-Segar is a full professor, senior executive, and international expert in policy, law, and governance on climate change, biodiversity, human rights, trade, investment, and financial law, and the world's sustainable development goals. She currently serves as Leverhulme Trust Visiting Professor at the University of Cambridge, UK, Executive Secretary of the Global Climate Law and Governance Initiative, CLGI, and the Senior Director of the Center for International Sustainable Development Law, CISDL, which is a proud sponsor of this event. She's also a Fellow of Law, Director of Studies at the Lucy Cavendish College, fellow at the Lauterprecht Center for International Law, visiting fellow at the Bennett Institute for Public Policy, and fellow at the Cambridge Center for Energy, Environment, and Natural Resource Governance. And Marie-Claire is going to talk today about the three COPs, the Biodiversity COP 16 in Cali, Colombia, the Climate COP 29 in Baku, Azerbaijan, and just briefly on the Desertification COP 16, which is still ongoing at Riyadh, Saudi Arabia. Over to you, Marie-Claire.
Well, thanks very much, Una. And I should actually say, I think you probably had a slightly outdated bio, because I now hold the chair in sustainable development law here in the University of Cambridge. But it built on what we did under the Lever Hume. And I'm happy to speak in capacity of that research and those publications, some of which are finally coming out, actually. One arrived today, so I'm super happy about it. The Routledge book on climate law and governance. Christina Voigt and I called it Courage, Contributions, and Compliance. So I'm actually celebrating that it's finally out after 9 years of work. I think maybe to respond to the question that I was given by the organizers about, how is international law advancing? And of course, I'll give full credit to the International Law Association in the work that we're doing in this regard worldwide, and then also in the COP. But as someone who got involved in the drafting of the United Nations Framework Convention on Climate Change, the at that time UN Global Biodiversity Convention, and the UN Convention to combat desertification of drought, the UNCCD, in 1991 and 92, through a series of prep comms as a young person, as a student representative, and then has followed from Rio, where those conventions were signed, and many individuals and organizations and countries made commitments to implement these three treaties in a explicitly different process that tried to bring in as much as possible, not just sort of experts in international law, but civil society organizations, women, youth, Indigenous peoples, business and industry, and many more. I think I would have to say that, having stayed involved for 30 years, I refuse to lose faith in the multilateral process. And I don't see the COPs as being something that could or should replace the thousands, indeed the millions of other local and Indigenous and youth and other initiatives that are going on around the world, including the ones on international law that the ILA is involved in. I see it as a floor and as a forum that has to be as inclusive as possible in the case of biodiversity, climate change, and desertification. Each COP needs to bring together the parties, the countries that made the commitments, and at the very least need to be held to account in a way that is transparent. But also to launch new initiatives, new commitments, voluntary and otherwise, and tighten their regime in an interactional way in order to further develop the rules. And we've seen that happen in nearly all three. Now, my colleague, Christina Voigt in Baku, actually said we're looking at a global climate law super year for the reasons that Payam underlined, actually. But I guess I would actually say we've got a global nature, climate, and land law super year, because what we've seen this fall is the meetings all in the same sort of 1.5 month period of the countries of the parties that have signed on to these treaties. First on climate, on biodiversity in Cali, every 2 years, the Biodiversity Convention and all of its protocols on access and benefit sharing, on biosafety, on liability and redress come together and meet. And the meeting of the Conference of the Parties Biodiversity Convention was held in October in Cali. And then in November in Baku in Azerbaijan, we came together for COP29 of the UN Framework Convention on Climate Change. to take some of the mandated steps that were required under the Paris Agreement. And then still ongoing now in Riyadh in Saudi Arabia, we're actually currently meeting for the Desertification Convention. And what I'll do is I'll just spend a couple minutes on each and then open for questions at the end once we've all had a chance to contribute. So in terms of CALI first, ILA, together with many other organizations, the International Bar Association, my tiny research center, CISDL at McGill, the Sustainable Development Law Association, our chair at Cambridge, and others, co-hosted the Biodiversity Law and Governance Day during CALI, bringing in over 2,000 registrants from around the world, 170 countries, to be able to discuss some of the really important advances that were being sought in the Biodiversity Convention. Now, as you probably know, replacing the Aichi targets as a sort of a post-2020 framework for biodiversity collaboration and bringing in all of the other biodiversity-related conventions, from the Convention on the International Trade in Endangered Species of Flora and Fauna, to the Convention on Migratory Species, to the Ramsar Convention on Wetlands of International Importance, and others. The Global Biodiversity Framework was agreed in Montreal 2 years ago in the COP15. And so COP16 was the first COP that had been held that was meant to look at the implementation, the action agenda, hosted by Colombia. And of course, given the country's recent history, the main focus was called Making Peace with Nature. And so it was looking very closely at conflict and finance and other aspects that are barriers, or if you can indeed make peace, ways, facilitators of action on biodiversity. And what we saw in the COP16, besides the Biodiversity Law and Governance Day surging forward as large as we've ever had it, was an expanded role for Indigenous peoples and local communities in protecting biodiversity, and also the operationalization of a new global mechanism to share benefits from the use of digital genetic information. And we've been talking about digital sequencing information, DSI, for a while in the COP, but this was the first time we'd actually been able to agree on that mechanism. There were about 119 countries, so the majority of the 196 parties to the CBD, that submitted our national biodiversity targets, reflecting our alignment with the Global Biodiversity Framework, what's called the Kunming-Montreal Global Biodiversity Framework. And 44 countries also had submitted their national biodiversity strategy and action plans. And one thing that I would sort of recommend for anyone listening or watching this video later online, each of these 3 treaties have a national action plan that they submit and then use to operationalize the treaty. And if you haven't done so already, check the website of the relevant treaty secretariat and see what your country is committed to. We do this in our online courses, our 3-week online courses for highly climate vulnerable countries under my chair, and it's quite extraordinary. Out of the 8,000 or 9,000 people who have taken our courses so far, nearly all of them have not seen their own country's nationally determined contribution or national biodiversity strategy and action plan or regional action plan under the Desertification Convention. And so one of the exercises we do with them is to actually have them have a chance to take a look at it, and then to think about how not just international law, but domestic laws at any level, including with the Indigenous folk who've joined us online to teach or to be trained, or the local and community folk who have joined us online to teach or to be trained. How changes in Indigenous law, how changes in municipal law, as in city council law, can actually make a change to the country's attempt to live up to its commitments. It's quite an extraordinary and not as discouraging as you would think exercise. So in CALI, we were able to set up a CALI fund, which needs to be operationalized and needs to be completed when the COP resumes. If you lose the sort of quorum because too many people have to leave, then you have to suspend the meeting, and we're going to be meeting again in February in Rome in order to complete the meeting. We also were able to take action on linking biodiversity and climate change. I think a colleague online will talk about strengthening the role of Indigenous peoples and local communities. So I won't try to sort of, do too much to steal his thunder, but rather just sort of focus on the other aspects that are perhaps less important than what the Indigenous peoples fought for and won in Cali. But more collaboration on capacity building, scientific and technical cooperation, knowledge management, decisions on ecologically or biologically significant marine areas, also decisions on sustainable wildlife management and plant conservation, as well as on biodiversity and health and risk assessment. But what we still need to get done in Rome, and what froze the meeting in the end, was the strategy for resource mobilization. We need about 200 billion annually by 2030 from all sources in order to support biodiversity initiatives worldwide, in line with Target 19 of the Global Biodiversity Framework. So, there's a need also to redirect or reduce harmful subsidies and incentives by at least 500 billion per year by 2030. And we haven't yet finished structuring that dedicated global financing instrument for biodiversity that is needed. We did, however, in Montreal and in Cali, set up a global biodiversity framework fund, which is administered by the Global Environment Facility, and about 163 million has been pledged toward that fund, with 400 million also having been pledged by the government of Quebec during COP16. And we also set up a Kunming Biodiversity Fund in Cali with 200 million pledged from the government of China. And I think that tells you how in coordination parties are or aren't, that you've got two separate funds with two slightly different mandates that are being set up in the same meeting. There's also a monitoring framework that needs to be decided, and that's also been reserved for Rome in order to provide the carbon yardsticks that the parties will use to measure progress against the 23 Global Biodiversity Framework targets. And there's a mechanism for planning, monitoring, reporting, and review. So what people who are spending a lot of time in the climate regime usually call MRV, or monitoring, reporting, and verification, is PMRR in the biodiversity context, and it has to do with not just monitoring, but also being transparent and being comparable in what you're agreeing and showing that you've done. So there's a national reporting template that hasn't yet been agreed. Without that, it's very hard to operationalize the Global Biodiversity Framework. So while a great deal was actually achieved, especially the new agreement on Article 8J that I'm guessing other colleagues will speak about, I think there's a great deal more that is still needed. And the new sort of World Coalition for Peace with Nature that the Colombian government launched and is open for signature is sort of only the beginning in this area. Now, I'll make maybe 2 or 3 little bullet points on Baku results, and then just 1 bullet point on Riyadh, because it's still ongoing, and there's not a lot that I would want to sort of advance there until the dust settled. Nothing is agreed until everything is agreed, just like in the trade negotiations. So in terms of the UNFCCC, there was a fair bit of grand drama in Baku, more than we expected, to be honest, speaking as someone who serves as a lawyer and has for several years for the highly climate vulnerable countries. It was quite existential drama for some who were gathered there. Over 200 countries in Baku, 55,000 participants, and we had to agree the new collective quantified goal on climate finance in order to be able to move forward. Mainly because next year, in line with the very, very worrisome findings of the global stocktake last year in Dubai, and in preparation for Belém, countries have to hand in their new national climate pledges, their new nationally determined contributions to the global response to climate change. And they can't hand those in, at least most countries in the world, the grand majority, 160 out of the nearly 200, without some idea of what kind of finance is available. So the quantified climate goal was quite existential, and Payam spoke a little bit more about why, so I won't go over more what he said. What I think is important is that in the end, what we achieved was certainly not enough, but it was progress. As Mary Robinson said, it's disappointing, but it gives us something to build on. It would have been much worse, especially given the various political changes in the world right around that time, to have failed entirely. The message that's sent is that we have something to build on. And we're tripling finance to developing countries. We had a previous goal of 100 billion annually, and we're now committed to mobilizing 300 billion annually by 2035. We're also working to secure the efforts of all actors to scale up finance from public and private sources to the amount of 1.3 trillion per year by 2035. And that's closer to what the science actually tells us we need. What is interesting is that depending on it's not just about the quantity, it's also about the quality of finance. And we had to achieve this finance goal we had to get that new quantified goal in Baku, and we did get it. We are actually expecting, if you look at the IEA numbers, global clean energy investment to exceed US 2 trillion for the first time in 2024. So a finance goal that commits to 1.3 trillion for developing countries per year by 2035 isn't actually off the table. And maybe the other three things that I would also just highlight for COP, as I said, we finally managed to get agreement on the what some of us call the Sustainable Development Mechanism. That's what it's called in the Paris Agreement. Carbon markets, it's under Article 6.4. We still didn't have rules agreed on that, and we finally now do. So not just on country-to-country trading, Article 6.2, the trade of carbon credits and how the registries will operate, but also the centralized carbon market under the UN, the Article 6.4 mechanisms, and the new Paris Agreement crediting mechanism being finally agreed means that we actually have some rules and some guidance for countries to be able to participate in the carbon markets that were promised many, many years ago, alongside the non-market approaches to climate action, and hadn't been delivered. We also got agreement on the enhanced transparency framework, the sort of reporting framework. Only 13 countries submitted their biennial transparency reports, their BTRs, and those are due from all 200 by the end of the year. So it's going to be a bit of a rush, or we're going to see a lot of people up in front of the compliance committee explaining themselves. But what was very interesting as part of that transparency framework that was agreed in Baku was a £3 million pledge by the UK International Forest Unit to be able to actually support the UN REDD+ program. There were 3 days of forest pavilion meetings to sort of look at how this could be done. And for lawyers, I think that's quite an achievement, because if you're going to enhance the transparency implementation of reducing emissions from deforestation and land degradation in line with our objectives from the global stocktake, to halt and reverse deforestation and forest degradation by 2030, you need very, very clear, not just technical assistance, but actually safeguards in place for forest dwellers and for others. And that was finally achieved in Baku. And then finally, I think I'll
Mary-Claire, sorry, we're going to have to wrap up. Can you
okay,
just...
I'll make two other points.
Okay.
We did make some progress on adaptation, and we did make some progress on the gender and climate change strategy in Baku. From Riyadh, the main discussions in the hallway, you can see in the UNCCD sort of press office what was being announced in terms of land degradation and drought. But the main discussions in the hallway, according to our delegation who are on the ground there, are actually that they're looking to put together a new protocol on drought. And that is probably going to be the most important piece. So thanks very much for not letting me get lost too much in the weeds there, Una. And that's my flying overview of 30 years of stop and start, hurry up and wait progress, a commitment to a multilateral regime, and a global super year on nature, climate, and land.
Awesome. Thank you so much. Yes, it was quite a challenge to pack that all into 15 minutes. Well done. Okay, wonderful. So our next speaker is Marcus Jewett. Mark has been a senior counsel and senior public service executive. He was formerly at Bennett Jones, the Bank of Canada, and the Department of Justice. He's an expert in financial regulation and public policy, and a longstanding member of the ILA Committee on Monetary Policy, and of course a member, like Mary-Claire and myself, of the board of ILA Canada. So over to you, Mark. Oh, sorry, I was going to say Mark is going to talk about sustainable finance and climate finance. Over to you. Thank you.
Okay, thank you, Una. I'll try and do this fairly briefly. As you mentioned, my main experience is in international monetary and financial law, and as a member of the International Monetary Law Committee, and also as a former central banker. central bankers have, somewhat surprisingly, been quite active in the area of climate change, which you might not expect. I'll just mention sort of three things, one of them leading into my particular discussion. The first is the Glasgow Financial Alliance for Net Zero, which was launched during COP26 in 2021. And it's committed to accelerating the decarbonization of the economy. And it provides tools and resources to help the financial sector implement net zero commitments. Second item is the Task Force on Climate-Related Financial Disclosures. And that promotes comprehensive climate risk disclosures. It's largely led by central banks, and it's got support from over 1,000 organizations. So it's mainstreaming climate-related financial reporting. And thirdly is something promoted by Mark Carney, who's the United Nations Special Envoy for Climate Action and Finance, and that's his advocacy for voluntary carbon markets, which saw well, certainly great progress, if not fruition, in Baku. Voluntary carbon markets, perhaps moving to mandatory, financing the transition to clean technologies and supporting emission reductions, and especially in emerging economies. So put that aside, and we'll try and talk about what happened at Baku. I would say at the outset that the conference yielded relatively few advances and attracted some very significant and justified criticisms, especially from developing countries. Now, you heard from Marie-Claire, who put, I thought, a very positive light on what happened. As you will see, I'm a bit less so, but it's important to look at these things positively. And the most widely publicized aspect of the conference was, of course, the climate finance agreement. It mobilized a pledge of at least $300 billion annually by 2035 to assist developing countries in addressing climate change impacts. Now, this was, I see, widely seen as inadequate or worse compared to the estimated 1.3 trillion needed annually. And the timeline extending to 2035 was also seen as too distant to address the immediate challenges faced by vulnerable countries. Again, we've already heard about that. But Baku marked the first time that a COP had dealt properly with finance. The only previous financial goal, as Marie-Claire mentioned, was for developed countries to ensure that 100 billion flowed to the developing world each year by 2020. And that goal was set as long ago as 2009 without any real discussion. Only a part of the promised total will come directly from the budgets of developed countries and public finance institutions like the World Bank. The great majority should be in the form of grants and low interest loans, but loose wording at the conference means that even that commitment has been hedged. The cash could come from, I think the quote was, a wide variety of sources, public and private, bilateral and multilateral, and alternative sources, spreading the blame, if you will. The remainder, the 1.3 trillion, would have to come largely from private sector investment in developing countries, with an unspecified amount supposed to come from potential new levies on shipping, frequent flyers, oil and gas, and other sources. All of these have yet to be agreed and could be difficult to achieve in practice. And as we saw, rich countries said the deal was as much as they could deliver. And again, as previous speakers have said, an additional sour note for COP29 was that it opened just 5 days after Donald Trump was reelected on a platform that promised he would again withdraw the US from the Paris Agreement and ditch climate action. And on this, sadly, we can probably believe him. So I don't think there's much point in spending more time here on the climate finance agreement other than to state the obvious. Too little from developed countries and not soon enough, 2035, a decade away. So I'd like to spend most of the rest of my time speaking more about quite a positive outcome, the adoption of a carbon market standards agreement, again, also referred to by Marie-Claire, which fleshes out Article 6 of the Paris Agreement, a rule book for international carbon credit trading, establishing standards for how such projects will operate. And this framework is truly essential to facilitate financial support for climate initiatives and promote global cooperation. Marie-Claire mentioned some other aspects, and I'll just run through them just list them. First was the Health Climate Initiative, the Baku COP presidency's Continuity Coalition for Climate and Health, aiming to integrate health considerations into climate policies. Fossil fuel influence, 1,700 fossil fuel lobbyists at the conference, raising pretty valid concerns about the undermining of climate action efforts and the integrity of the negotiation process. Human rights concerns, well, Azerbaijan does not have a very good record. And fourth, organizational challenges. It was rather disorganized and disingenuous hosting, and the absence of several world leaders and countries. So that did not help either. So it's back to Article 6 of the Paris Agreement. I'll spend the rest of my time on that. So this is a significant development that I would hope, trying to be positive, will pave the way for the operation of a global carbon crediting mechanism. Now, that concept had been around for a long time, both globally and domestically, and it has its critics, but the generation, purchase, and sale of carbon credits through the carbon markets can play a critical role in the ability of countries and businesses to meet their emission reduction goals and achieve net zero. Carbon markets can serve as a platform where parties can transact carbon credits, which can be used to offset an entity's emissions. Through these markets, entities engaging in activities that either remove or reduce emissions from the atmosphere can generate carbon credits, which can then be sold. Entities that cannot reduce their emissions through business and operational changes purchase these carbon credits to offset their emissions. I mean, that's Cole's note summary of it, but it's been around for a long time. It works some places, it doesn't work so well in others. So Article 6 of Paris addresses how carbon credits generated can be transferred between countries and be used to help meet climate action plans and targets. Article 6.4 provides that an integrated and global carbon crediting mechanism will be established to facilitate the trading of carbon credits, overseen by a supervisory body. The carbon credits that are traded will be validated, verified, and issued under the framework, and can be used to meet climate targets. Until COP29, countries had not agreed on the principles that should apply to the carbon market. So this is a big step forward. Two sets of standards adopted. The first set addresses the requirements for the methodologies, real, transparent, conservative, and credible. We'll see how that works in practice, but you've got a third-party verification systems, you've got data-driven technical performance standards, and transparent demonstrations of the changes in emissions achieved by and attributable to the activity. There's an important additional requirement that they identify the business as usual emissions or reference benchmark emissions, and also specify the approach an approach to demonstrate the additionality of the activity and to avoid leakage. So the additionality is an assessment that shows the activity that would not have occurred without the incentives from the carbon credits, accounts for relevant national policies, and exceeds any mitigation required by law or regulation. There's also methodologies to avoid leakage. There's a second set of standards which addresses the requirements for emissions removal and emissions reduction projects with reversal risks. These requirements include ensuring that the monitoring is carried out based on good data. Second, a monitoring report after implementation. And third, quite important, a consistent unit of measurement. So, second part of the question we were asked, what are the potential impacts of the adoption of standards? I would say first, it will and certainly could open up a large market in which countries and businesses can generate, sell, and purchase carbon credits. While many entities already transact in the voluntary carbon markets that I mentioned, this provides a forum to purchase and sell carbon credits, and the voluntary markets are continuing to develop and expand. So an international carbon market backed by the UN could be an attractive option, and the adoption of these standards can facilitate standardization and transparency in the market. Second, the newly adopted standards can have some effect on the standards and the requirements currently being applied. So you may see some modifications. The requirements set forth in the standards can be adopted in climate legislation, examples like the California Voluntary Carbon Market Disclosures Act, which requires companies operating in California that purchase carbon offsets to make disclosures on their websites starting in January this year or next year. So other climate legislation could also be adopted. So this sets out a framework within which the global carbon crediting mechanism will operate. There's a lot of additional work, a lot of detail necessary to further develop the standards and explain how they'll be implemented and applied. Clearly a lot more to be done, but I don't think there's any doubt that the adoption of the standards represents significant progress toward the operation of a global carbon market. And speaking as an international law plumber, I find that this is probably the single most tangible, significant outcome of Baku that I saw. Again, speaking as a plumber. This really should increase confidence in the carbon markets and encourage continued investment. Now, I'll just close with this. The whole notion of carbon markets is often criticized by experts, some experts. They say the new rules don't prevent misuse, they don't work, they merely give big polluters an excuse to continue emitting. And there are undoubtedly valid criticisms to be made. The rules are imperfect. They're not going to be without fault. But the adoption of these standards seems to me a very important step forward. So it would be a gross overstatement to call COP29 a success, but the adoption of these standards, I think, is a very positive step, and one that we will see more of even in the coming year. And I'll close it there. Thank you.
Very much for that, Marcus. And I think, in fact, your presentation answered some of the questions that were coming up in the Q&A. But I would suggest that if folks in the panel have answers to some of those questions, it would be helpful if you could just type them back to some of the participants. Thank you. Thank you so much for that. So we're going to move off from COPs to the next topic, which is the plastic pollution treaty that people are trying to draft. And it's my pleasure to introduce to you Dr. Alexandra Harrington. She is an international jurist in human rights, environmental and climate change law, and both a professor of law at Albany Law School and assistant director of the Global Institute for Health and Human Rights. In addition, Alexandra is Director of Studies for the International Law Association of Colombia, a member of the ILA Committee on the Role of International Law in Sustainable Natural Resource Management for Development, and is lead counsel for Peace, Justice, and Governance at the Center for International Sustainable Development Law. So, as I mentioned, Alexandra is going to talk to us about the recent UNEP INC 5 plastic pollution treaty discussions that took place in Busan, South Korea. And I have this question, did it have anything to do with what happened immediately after you guys left the country? But anyway, over to you, Alexandra.
Well, I've had that question a number of times, I really have. And I literally had someone go, did you do this? So anyway, the timing was fantastic. Thank you so much for the introduction. I think I in the craziness of Korea, I forgot to send you a proper updated biography. So I'm actually now at Lancaster University in the UK, and doing a number of other things relating to pollution, including, as you will see when I figure out how to share my screen properly, which I will do in a minute, serving as the chair of the International Union for Conservation of Nature World Commission on Environmental Law's task force on the plastic pollution treaty. So there are some interesting developments coming out. I do promise, sadly, for those who are looking for interesting news, that we did not have anything to do, I think, with the attempted martial law implementation, although we were all quite lucky to be kind of out when everything happened. But just to give a brief update and also background, because I realize that many people will have missed perhaps our event before the 4th INC, which we did as a wonderful online event. Una very kindly brought together ILA Canada to talk about the session there in April. And so I wanted to give a bit of a background on where we are in this process of trying to negotiate a plastic pollution treaty, or as we call it affectionately, the ILBI, which is the international legally binding instrument on plastic pollution, as required by the UNEA 5 resolution, or 514 resolution from 2022. In this resolution from the UN Environment Assembly, so now almost 3 years ago, there was an authorization for negotiations and the creation of an international entity, what we call an INC, which is an Intergovernmental Negotiating Committee, to negotiate the ILBI. And the ambition was that this process would be concluded by the end of 2024. As a result, we were given authorization to have 5 rounds of meetings of the INC itself. This was what was in the actual framework of the UNEA resolution, along with a mandate to create an ILBI that is life cycle addressing and appropriate. So addresses all aspects of the plastics life cycle, from their creation to their sale and transfer to use by consumers as intended on the market, and then ultimately to the waste management issues. So either reuse, recycle, etc., or finally the end of life kind of waste management aspects of the unrecyclable plastics. So it is quite a broad remit to have. And as a result, we had this schedule of meetings. The first INC was very much aspirational in many senses, and we had a much more kind of positive outlook, I think, in many ways on how the process would work, and also why we were coming together to have a treaty to begin with. We had our second INC meeting in May 2023 in Paris. And during that meeting, we saw a very interesting evolution of the rules of procedure being quite critical in the negotiations themselves. And typically, many lawyers kind of understand the value of rules of procedure in a way that other others don't. Other outsiders to the legal profession don't understand. But here, everyone learned the importance of the rules of procedure because this was raised by several countries, primarily Russia and Saudi Arabia, who were concerned about certain aspects of the rules of procedure adopted for the negotiations, which would allow, as UNEA rules allow, the use of a vote, a majority vote, if there was a deadlock in consensus at any point in the negotiations. So this was an issue that came up. It was negotiated for several days. Ultimately, there was a text added, a note added to the rules of procedure expressing the statements of many countries, or several countries, that there was a concern about how this would be applied and the idea of trying to use consensus moving forward. There is a reason I mentioned rules of procedure and not just talk about the context of plastic. You will see that very shortly when we talk about INC 5. In November of 2023, we had INC 3. And now at INC 3, we moved into the first efforts to have an actual negotiation of textual elements. So INC 1 was very much an opening. INC 2 was a lot more sharing of ideas, sharing of concerns, areas that should be addressed, and in some instances, proposals of text, but largely just discussions about what should be included in various aspects of the treaty. And when we got to INC 3, the first textual draft was given to all of us acting as negotiators, be it for international organizations or as a legal advisor to countries or countries themselves. And at INC 3, we used what was called the zero draft. Many of you who are familiar with treaty negotiations will know this language well. And the zero draft was relatively small. It was used as the starting off point to get opinions, to then solicit textual proposals, etc., and was based on what came out of Paris, as well as an open call for proposals and for discussions and comments from states and stakeholders that had been issued in the intersessional period. Then we moved into Ottawa and we had our wonderful event. Una, again, thank you for now giving me 2 opportunities to speak on this during INC 4, during the thick of it, really. But we were using there the revised zero draft, and the revised zero draft had gone from approximately 20 pages in the zero draft to 70 pages of negotiating text, reflecting all the proposals that came out of Nairobi. And INC 4 had many slow points, many points of contention. One of the things that it did authorize when we were finished at the end was the convening of intersessional meetings, intersessional groups, as ad hoc open-ended expert groups in Bangkok, which took place in August of 2024, with a lead up of multiple meetings beforehand online, and also the creation of a legal drafting group, which would then function at INC 5 as needed. And I was very lucky, I still am very lucky to be a member of that legal drafting group and to represent Guinea-Bissau, which is truly a privilege. So that was called for INC 5. During the intersessional meetings in Bangkok, which were somewhat limited, and there was a bit of criticism of the process here because it was limited to those who were deemed technical experts and nominated by various countries. Again, I was very lucky to sit in the room as a legal expert to Sao Tome and Principe. But in these discussions, it was very clear that a number of different, very divergent views had come into place in terms of how we define and regulate chemicals, plastic products, plastic polymers, and product design under the treaty. So very much the binding elements. And then also how we create a financing mechanism that would provide capacity building, technology assistance, and a number of other financial entity responses to the needs for climate change. Climate change. I gave a climate change lecture this morning. The needs of plastic pollution, and where that would be housed. And a very significant rift started to appear here between countries that wanted it to be housed in the Global Environment Facility or the World Bank, On the one hand, as we've seen a number of funds do recently with biodiversity beyond national jurisdiction, the BB&J, aspects of the Global Biodiversity Framework funding, et cetera. And countries that were very wary of using the GEF and using established financing mechanisms and were and still are very much attached to the idea of creating a new financing mechanism that would be specific to the plastics treaty and in many ways would mirror what we've seen from the Montreal Protocol thus far. So we ended with a bit of a division in August. And then we went into INC 5 in Busan before everything started to kick off a bit in November of 2024. Now, in advance of this, the chair of the INC process, which has switched. So in the beginning, it was chaired by Peru, and then it switched over after INC 3 to being chaired by Ecuador. The chair created what he called a non-paper, because legally there was no authorization from the INC and INC 4 to actually create this. So it was a non-paper with a suggestion of areas where there could be potentially convergence between countries and some proposed text for what a treaty might look like. This was heavily criticized by many because it didn't have a number of elements that were very critical, like extended producer responsibility and aspects of international cooperation, definitions, etc. But it was intended to be a much shorter document at 15 pages than the 77 pages of the compilation document, which had been issued after INC 4 and represented everything that was suggested at INC 4, but was certainly much larger. So after much debate, the negotiations ultimately were based on the chair's non-paper, but with the expressibility of states to propose new text. And many did bring in text from the compilation document into various proposals that were created. We had a full week, so we had 7 days to negotiate. Unfortunately, as many will know, we ended in a bit of a deadlock. To try to break the deadlock, there were 2 additional non-papers issued by the chair. The first was on November 29th. It gets very confusing with the non-paper nomenclature, so we've just started referring to them by date. So the 29th of November, and then also the 1st of December on the very last day to try to facilitate progress. But ultimately, there was a decision to adjourn INC 5. Again, because the UNEA resolution only allowed for the 5 negotiating sessions, we will not be moving into an INC 6. We will be moving into an INC 5.2 at a date to be determined soon, hopefully, and a location to be hopefully determined soon as well, where there is a very strong hope that we would then be able to develop a final text for the plastics treaty. The areas of real divergence, again, focused on what we would be regulating. So the binding elements and measures, as well as financing. And interestingly, also, the idea of scope and principles and objectives has become quite prevalent. Typically, these are things we don't necessarily spend as much time on, obviously, as the binding elements. But here, these were brought back into the discussion by a concerted group of parties who were very adamant that they should be discussed and they should be potentially quite limited. There also, interestingly, is actually a dichotomy emerging between the ratification process itself and the entry into force. And so we've seen a great deal of discussion back and forth about whether this should be 50 states being required for entry into force to have ratified, or 60, as in the Biodiversity Beyond National Jurisdiction agreement, or interestingly, 97 is currently a proposed element as well. We can all try to figure that out in our heads, and then debate over what would be the time frame once that number of ratifications is hit. Would it be 90 days, 120 days, a year, et cetera? So we're seeing a lot of the typically very formulaic elements of treaties being much more controversial in this setting. And just quickly to explain, again, we will need to have conferences of the parties, we will need to have annexes, etc. No matter what the text is, I think there is really an agreement on that at this point. to quickly explain what comes next, once there is actually a treaty, we will have to have what we would call a PrepCon, so a preparatory convention, to set out the plans for then the diplomatic conference. Diplomatic conference would be where, again, it would be signed. And then once we had the ratifications that we would need to then have it enter into force, there would be the plan for the first conference of the parties, which will be critical. And it will be critical because the design in a number of aspects of the chair's non-paper and also the compilation document and the negotiation statements will be where a number of issues will potentially be decided, where guidelines will be adopted. And right now, the first two, at least, conferences of the parties will be where a great deal of decision-making goes, and a lot of the continued negotiation will go, presumably once the treaty text is adopted. So how we get there is a question in terms that is still very much open in terms of what the potential is for intersessional work during the period between the diplomatic conference and the first conference of the parties. So how we can make sure procedurally we can have very clear documents, very clear information going into the first COP to try to facilitate the decisions that we're expected to have to see made during the COPs. So it is very much up in the air. We are all, I will stop sharing, we are all very much hopeful that we did not, in fact, cause the martial law attempt. I don't think we did. I think we were all relatively well behaved, but you never know. But we do thank the government of Korea for hosting. It was a quite lovely event in many ways, and certainly demonstrates, as we've seen with CBD, as we've also seen with the negotiations to create a science policy panel that would be the equivalent for pollution of IPES and IPCC, a trend, I think, where we are seeing the negotiation times dragging out, and we're starting to have a 0.2 coming in as a more accepted practice than previously. So with that, I'm very happy to stop talking and hand back over. And I know there is at least one question in the chat, so if it wasn't addressed, please let me know. But I would just add to address that question that indeed the transboundary movement of plastic in the oceans is certainly a very popular element to include in the treaty, and the treaty will most likely apply to that as well in the future. So thank you for the question, and thank you, Una.
Thanks so much for that, Alexandra. And if you want to add more detail in your response to that question in the chat, in the Q&A, that would be very helpful, because we won't have much time to answer the questions otherwise. So it's with great pleasure I'm going to introduce our last panelist, and that is Dr. Graham Reed. He's a strategic advisor with the Assembly of First Nations, AFN, where he advocates for the inclusion of First Nations in international, national, and regional climate change and energy policy dialogues. He has had the privilege of representing AFN in a wide variety of contexts, including as board members of the Climate Action Network Canada, CANRAC, member of the Canadian Environmental Domestic Advisory Group, CISDL, which I enjoyed being a partner with them on, and Indigenous North American representative to the facilitative working group of the Local Communities and Indigenous Peoples Platform at the UN Framework Convention on Climate Change, the UNFCCC. He completed his doctorate from the University of Guelph in 2022, studying the intersection of Indigenous governance, environmental governance, and the climate crisis, and is currently a postdoctoral associate at the Center for Indigenous Knowledge and Languages at York University. Graham will be discussing aspects of the climate change negotiations, the plastic negotiations, and the focus of the Permanent Forum on the Rights of Indigenous Peoples, or MRIP, on transitional minerals. Over to you, Graham. Thank you.
Yeah, awesome. Miigwech, Una, Anin Bojo, Graham Reed, Nishikazado, and Jvanish Nabayandao. Yeah, very honored to join all of you on this panel and explore the implications of international environmental law for people and planet. I am joining from unceded and surrendered Algonquin and Anishinaabe, what's currently known as Ottawa, where I grew up. I left for a while and then came back. Dad's side is English and Scottish, and mom's is German and Anishinaabe from the Great Lakes. Yeah, I mean, I'm going to do this relatively short just because we don't have a ton of time. But I think it's interesting to discuss the connections between international environmental law and international law more broadly, and also as that relates to the participation of Indigenous peoples and the affirmation of the individual and collective rights of Indigenous peoples as affirmed in international documents like the UN Declaration on the Rights of Indigenous Peoples. 100 years ago, last year, Descate first went to the United Nations, then the League of Nations, to essentially assert the Haudenosaunee's Confederacy's presence within the international legal environment and complain about the lack of adherence of states, both the US and Canada, for the basic enjoyment of their human rights, both individual and collective. And so I think it was interesting that, Parvan or Payam, sorry, spoke a little bit about the way in which small island states are turning to courts to enforce the basic protections of their rights. And for Indigenous peoples, especially within Canada, that's actually been the only way in which Indigenous peoples have seen any recognition of their rights. And so, we see this continuation of the potential framing of how Indigenous peoples continue to lead discussions on what that means in practice. For those who don't know why this is so important, there's about 470 million Indigenous peoples across the globe in about 90 plus countries. And so there's a significant presence of Indigenous peoples, both with respect to those that are Indigenous majority states, like many of the examples that were shared in the CIDS and the small island developing states, but also those in minority contexts like Canada, like the United States and many others. And I wanted to kind of focus on three areas and then the implications that I think we could probably talk about within this space. One is just the institutional recognition that Indigenous peoples are advocating for and seeing, and that relates to the establishment of the permanent subsidiary body on Article 8J. An open-ended working group that was created 2 decades ago to talk about the inclusion of traditional knowledge, and now there's the step up in the creation of that permanent subsidiary body that obviously took multiple years of advocacy, but is a potential space for the communication and priorities of Indigenous peoples within the CBD. There's the continuation of the body that I sat on, the facilitative working group of the local communities and Indigenous peoples platform within the UN Framework Convention on Climate Change, which is the only body within the entirety of the UN system that enables Indigenous peoples to appoint representatives directly, even in those bodies that exist, such as the UN Permanent Forum on Indigenous Issues or the Expert Mechanism on the Rights of Indigenous Peoples, actually have a two-step process where it's non-Indigenous organizations and state representatives that are determining whether or not those representatives will be appointed to those bodies. And we heard a quite controversial appointment in the context of the Permanent Forum for the Asian region several years ago. There was a representative that Indigenous peoples advocated for, and then there were those that states essentially supported. And then, of course, the enhanced participation discussion, which is occurring both within the General Assembly and in the Human Rights Council. And I reference that largely because I think those processes are illustrations that UN mechanisms, conventions, etc., are ill-equipped to acknowledge the self-determination and nationhood of Indigenous peoples, and in fact actually replicate the systematic erasure of their presence and collective rights. And so even the affirmation of their participation as representatives that can contribute to, for instance, permanent subsidiary bodies, we're still not at the point where we are exercising decision making on equal terms with other representatives. And so, there's this interesting dynamic that we see between states, but also within states that is manifesting and in fact is like really inappropriately considered within negotiations like the UNFCCC, also like the Plastics Convention as well, which Indigenous peoples have zero voice. And broadly speaking, civil society has a quite limited voice. We've worked really hard with Canada to ensure that voice is represented within the formal negotiation spaces, but ultimately when that changes, when the government changes, that voice is ill-equipped to carry those priorities. And then I wanted to touch just briefly on two pieces and then talk maybe about the implications that I see for all of it. One is the increasing recognition and focus on the question around transitional and critical minerals. And we saw that as a study of the permanent forum that was launched last year. An expert group was hosted earlier this year to talk really about what are the ways in which that Indigenous peoples are concerned that the acceleration towards the development of critical minerals can actually reproduce the same colonial practices of extraction that have defined the way in which Indigenous peoples have interrelated or interacted with the state itself. And so there was an Indigenous summit hosted in October in Geneva, and there was a series of protocols and principles that Indigenous peoples from the 7 UN sociocultural regions described and defined in order to really characterize what do these concepts mean, whether that's a just transition, whether that's green energy, whether that's critical minerals, from Indigenous epistemologies and ontologies, and how do we use that as a basis for our collective advocacy, recognizing that may or may not be considered within dominant discourses. And then finally, I think there's, we have this global movement predominantly led by Indigenous peoples to end the conflation between Indigenous peoples and local communities. And as we exist within the kind of international law, we know that there's no defined definition of what local communities are, and state recognition is not a prerequisite for indigeneity. And so what are the ways in which we're navigating essentially the assertion of Indigenous identity as separate and distinct from that of local communities? And of course, we have the greatest examples that were advanced in Kali around Afro-descendants or others, but those are also distinct from Indigenous peoples and have sometimes positive and sometimes negative relationship with Indigenous peoples, lands, waters, and territories. And so how are we creating space to end the conflation and acknowledge the distinct status and rights of Indigenous peoples? And we're seeing that within the 3 UN mechanisms dedicated to the rights of Indigenous peoples, the Permanent Forum, MRIP, and the Special Rapporteur, and also seeing how that translates into the negotiations. And obviously the CBD is the hardest place. There's a lot more support within the UNFCCC. There's a lot more support within the Plastics Treaty. There's a lot more support within the Permanent Forum and the NRIP. And so how do we make those advancements to acknowledge that distinctiveness? I have a couple minutes, and I maybe just want to focus on like some of the implications that I see within this work, and what are the ongoing contributions that we can see through the establishment of distinct space for Indigenous peoples in a way that acknowledges their epistemologies, worldviews, rights, etc. And I think that the first is that we see the challenging of the ontological dependency that exists within international agreements, which is to say that our understandings of certain concepts comes from certain ways of thinking. For instance, how do we understand mitigation? How do we understand the root objective of the Paris Agreement to keep warming under 2 degrees and all efforts under 1.5? How do we understand just transition within these spaces that were created by largely non-Indigenous entities? And as a result, how do we create the ceremony space for the ethical engagement within those assumptions? And how does that affect our worldview approach, the ambiguity that presents itself? And are we indirectly accepting replications and systems of harm that have contributed to the problem we're aspiring to solve? I think the greatest example that we can use is obviously the carbon markets that both Mark and Marie-Claire spoke to. I think there is an open question to say, is the commodification of life itself an effective vehicle to address the extraction that is actually caused by the same technology and markets that is aspiring to be created as a solution? And so, if we don't spend that time thinking about that and thinking about our specific positionality, we actually may be replicating systems of harm. I can get in a really nerdy example about integrated assessment models, but I won't. I'll just save all of you for that. And so for me, the fundamental question then becomes, do these institutional arrangements serve the future, that just, equitable, and resilient future that I think a lot of us are advocating in these spaces? And I think it's interesting that we're talking about the way in which, for instance, small island developing states are communicating the urgency of climate action, the way in which Indigenous peoples are communicating the urgency of climate action for decades. In 92, we know that the Parallel Declaration, the Kaiorka Declaration from Indigenous peoples, offered a different vision of what the root cause of the climate crisis, the biodiversity crisis, the plastics crisis really was. And that's that imbalanced relationship with the natural world, the assumption of superiority that humanity seems to advance within all of these spaces. And so how are we, questioning whether or not these institutions are appropriately designed to address that? And I do think that there's a lot of lessons from mechanisms of Indigenous, and whether we describe it as multilateralism, whether we describe it as solidarity building, whether we describe it as the exercise of our self-determination and our diplomacies, can actually inform better relationships within that space, not only to each other, but also to ourselves and to the world around us. And I guess I'll conclude by just saying, when I enter into these spaces, and I think, we can, as academics, as technical experts, as legal experts, can often exist within these spaces with only two sides of our being, our physical and our mental. And what many Indigenous peoples are asking and what are advocating for is, how do we acknowledge that emotional and spiritual element of us as whole beings? And so how do we enter that into spaces that aren't created for that, in order to create parallel futures that, may or may not enable us to avert the catastrophic impacts of a system that actually is continuing and replicating those systems of harm, and whether or not that we're doing this in a way that can address that for our future generations. So that was a little bit longer than expected, and miigwech. Miigwech to everybody and my fellow panelists, and look forward to those conversations moving forward.
Oh, thank you so much, Graham, for those comments. And I'm really happy that you come last at this panel, because I think it really does talk to futures, that, speculating about the futures we want for this planet. We've heard today from wonderful experts on the international law that's developing, the challenges that are coming. And I think especially the sort of spinning of the wheels that we see all the time and the slowness of progress, it really does point to that big question that Graham has asked about, if you use the tools of the master, will you be able to liberate yourself from the master? And if that master is, sort of a entirely resource extractive model of the universe, colonialist kind of model, good luck. Are we really going to achieve it? So they're really interesting questions. And it certainly, to me, it points to the importance of having various fora where we, people who are trained in the system, can learn from people who have other perspectives, and especially Indigenous perspectives on relationships with land, and how we make law that captures the spirit of the people and the planet together. So really exciting, and difficult but promising ideas that have been discussed today. I'd just like to, we don't have time for to deal with the other questions, but thank you so much for your questions, everybody. And thank you so much for the presentations by the wonderful experts on this panel. I think we've really done a great job of, you have done a great job of summarizing an amazing year. Clearly, there's a great deal more to come. And so let's hope 2025 is a good year, not a particularly hot year, let's hope. Let's hope we make some progress on that front. So on behalf of everyone on the webinar, I'd like to thank our speakers for providing so much useful information today. And I thank the audience for your attention and probing questions. Please follow ILA Canada and ILA on our respective websites and social media for our next events. And you're most welcome to join the exciting and supportive international law community of ILA Canada. And please note that if you're a student, we do provide free membership for you. Anyway, I wish everyone a wonderful afternoon or rest of the day. Some of you are already in the evening. And best wishes for the holiday seasons. And we'll see you in the new year. So thank you so much. Bye-bye.
Thanks, everyone. Miigwech.
Thank you all. Thanks, Una, especially. Take care. Happy holidays.
Thank you very much.